Abortion is not a crime, in my view. It is a medical procedure.
Abortion has been safely and legally available at the option of the woman in Victoria for decades.
Victoria really will be the abortion state.
I've become disturbed in recent weeks at the extreme tone of some abusive correspondence and phone calls that my electorate office staff and I've received.
Welcome back to The World from Below. That was a clip of some Victorian MPs speaking during the debate to decriminalise abortion. We're discussing reproductive rights this week, and our guests are Dr Ronli Sifris from Monash University and Rachel Ball from the Human Rights Law Centre. We turn now to take a closer look at conscientious objection to abortion on the part of doctors. Former Liberal and now independent Victorian MP Geoff Shaw threatened to introduce a private members' bill in May, which would have seen gender selection and late-term abortions outlawed and obligated doctors to resuscitate babies who survived abortion attempts. Shaw also flagged an intention to repeal Section 8 of the legislation, which deals with conscientious objection to abortion by doctors. In both Victoria and under an equivalent provision in Tasmania, doctors who object to abortions are required to refer their patient to doctors who don't. Rachel, if abortion is lawful, how important is the requirement of doctors to refer it on if they have a conscientious objection to abortion?
Well, those provisions are Parliament's way of trying to strike a balance between the rights and interests of doctors and also the rights and interests of women who are seeking medical care. And I think, you explained the way in which the provisions operate. They're obviously really important to ensure women's access to reproductive health services. And the thing that I found really disappointing in a lot of the debate, especially here in Victoria about conscientious objection, is that the people who oppose those referral provisions will often talk about them only in the context of the rights and interests of the doctors and leave the position that women are in out of the picture. Obviously, if you go to your doctor, you're going to them, it's a position of trust. The doctors are in a position of power or privilege over their patients in some respects, and so it's very important that they not breach that trust and they provide full and correct information to women who are seeking services.
I mean, it really is about what Ronli was talking about before. It really is about allowing the woman to make the decision rather than deferring to the doctor and the doctor's medical opinion. I mean, is that right? Is that what your view is as well?
Yes, and ensuring that she has all the information that the right to receive in order to make that decision.
Ronli, how has conscientious objection worked as a concept in other countries? Can you tell us a bit about it?
Sure. I suppose there are some places where in some ways it doesn't have a huge practical impact. So, where you're dealing with a circumstance where you have lots of doctors and only a conscientious objection to abortion, then the practical effects are often not enormous. But there are other contexts, for example, in lots of rural areas where the one doctor in town may happen to also have a conscientious objection to abortion. And then the consequences can be very serious for the women concerned. Also in countries where the vast majority of doctors in any given location may have a conscientious objection, or indeed the main hospitals may have a sort of institutional conscientious to abortion, that the consequences can be quite serious. So one particular example that comes to mind is the example of Peru, where a case was actually brought before the United Nations Committee on the Elimination of Discrimination Against Women in circumstances where a teenager who had been sexually abused and become pregnant as a result of that sexual abuse, was injured in an attempt to commit suicide, very seriously injured. She suffered spinal injuries and she was taken to hospital, and essentially the hospital refused to either perform the surgery that was necessary help to deal with her injuries, and refused to terminate the pregnancy, and they refused to perform the surgery on the basis that it may result in a termination of the pregnancy. And so as a result of this conscientious objection of the hospital, she ended up being paralysed. And so that's obviously a very extreme, very traumatic example, but it does very clearly demonstrate the point of the potential implications of doctors and hospitals as institutions having a conscientious objection to abortion in circumstances where the woman in question may have nowhere else to go to.
I mean, that is quite a shocking and confronting example, and it seems to be a situation as well where the patient is no longer the woman, it's also, or in fact only, the fetus that's unborn, and that strikes me as very troubling from even the perspective of patients' rights in medical treatment with their doctors.
Yeah, that's exactly right. And the interesting thing with this example in Peru is that therapeutic abortion in this context was actually legal in Peru. So this wasn't a situation which we sometimes see where the reason that the hospital will refuse to allow an abortion is because they're scared of being prosecuted. The law in Peru did allow an abortion to take place in this context. So it really was very, very troubling that the hospital took the approach that it did in terms of, as you say, whose rights were being safeguarded and who the patient actually was in question.
Rachel, there's been numerous reports internationally about misinformation being provided to women and girls from counsellors when they're seeking advice about abortion. Is there anything that can be done about this? What can we do to ensure that women receive accurate information about their reproductive choices?
Well, it's not just internationally. This is something that happens all the time in Australia as well. In Australia, there's a lot of pregnancy counselling services, often they'll call themselves crisis pregnancy services, that in fact are faith-based or anti-abortion. They don't disclose that in their advertising literature, and women contact them expecting to get fair, impartial, full information about the options that are open to them, and instead get lectured, get shown confronting pictures of aborted fetuses, get fed medical misinformation, lies about links to breast cancer or infertility or depression. All these sorts of things are happening regularly in Australia at the moment. There were attempts several years ago in the Senate to pass a bill that would require pregnancy counselling services to disclose their positions if they're anti-abortion, but that bill didn't end up going anywhere, so it's an ongoing problem here as well.
In some respects, it's something that should be regulated by the professional conduct rules that govern how medical professionals work, but I also think probably the conscientious objection provisions installed in the legislation give some protection from a criticism based on professional misconduct. I mean, is there ways in which you can make complaints about medical professionals on that basis? Is that a sufficient way to deal with the issue?
Well, I'm sure that there are, and Ronli might know more about the procedures and medical ethics around some of these issues. But the thing with some of these sorts of services is that they probably don't fall within the scope of those regulations. And women who access them have no way of knowing what laws they're governed by or what interests are guiding their practice.
Before we go to the next break, Ronli, I just wanted to ask you quickly, we've seen a lot of setbacks for abortion providers in the United States through quite targeted regulation aimed at them. What are some of the ways in which that works in the United States and around the world?
Look, on the subject, I guess, of reproductive freedom generally globally, if I can maybe just sort of deviate for a minute, because I think it's kind of important to note that even though we're talking about abortion now, when we talk about reproductive rights and reproductive freedom, what we're actually talking about is something much, much broader than just the abortion right. And there are lots of issues globally which concern reproductive rights in general, which have nothing to do with abortion. So things like the right to be free from involuntary sterilisation, or the right to access contraception, or the right to adequate reproductive health care, or the right to choose one's method of childbirth. These are all really important aspects of reproductive freedom that aren't, that don't fall within the abortion right, but are still really, really important on a global level. So if we take involuntary sterilisation as an example, you know, in China there have been numerous instances of involuntary sterilisation as part of the implementation of the one-child policy. In Peru during Fujimori's regime around 2000, there were lots of Indigenous women who were subjected to involuntary sterilisation. In countries like the Czech Republic and Slovakia, Roma women have been subjected to involuntary sterilisation as a method to try and curb the Roma birth rate. And you know, in Australia just last year there was a Senate committee report looking at the issue of involuntary sterilisation in the context of women with disabilities and also intersex people. And so I think if we're looking at this issue of reproductive freedom generally on a global scale, we really need to be looking much more broadly than just talking about the right to terminate a pregnancy, even though that's obviously also a really important a really important right. Yeah.
Okay, we're going to take a quick break, but we'll be back to talk about reproductive freedom and the law as it relates to the unborn. Stay with us.